Segment 4, the 10th anniversary of...
Oh, God. Bush v. Road.
Bush v. Gore.
Yeah,
Bush v. Gore. Bush v. Gore.
Yes.
December 2000, the Supreme Court ends the Florida recount, enabling George W. Bush to claim victory in the presidential election. Two quotations. One, Jeffrey Toobin in The New Yorker. Quote, "What made the decision so startling is that it was the work of justices who were judicial conservatives. These justices had said they believed in the preeminence of states' rights. Bush versus Gore violated those principles."
He doesn't know what he's talking about.
Quotation 2. Who needs quotation 2 when you have Richard here? George Will, quote, "The U.S. Supreme Court was duty-bound not to defer to a state court that was patently misinterpreting, disregarding, actually, state law pertaining to a matter assigned by the U.S. Constitution to state legislatures," close quote, since you've already opined.
I wrote that article.
Which
that's my view.
That's your view.
Yeah, I agree. I take that view too. But the claim that the conservative justices were somehow hypocritical because they're true conservatives means that they can never strike down any law ever. That's just a silly, sort of hackneyed, sort of simplification of what a judicial conservative is. You could take the exact flip side argument and say, well, would Toobin have said the judicial liberals on the court weren't they being hypocrites because they were supporting state rights, in this case against the federal government? Of course not, but that's the natural implication of that kind of claim. The real thing here is, and it's Richard's point too, is that the federal law required the state of Florida to count its votes in a somewhat fair way, and then to get the electoral votes in by a certain date. Right, and Florida wanted to ignore that date. The Florida Supreme Court wanted to ignore that date and keep counting in all kinds of different processes. But I actually think, getting into arguments about judicial conservatism, liberalism, if there's one kind of case I think the Supreme Court should decide, it's when there are
like the president.
Yes, misfirings in the electoral process. Right, when the constitutional system of democracy and those kind of rules are breaking down, the court can intervene, decide those, and it doesn't cause widespread disruption in society like gay marriage or Obamacare and so on.
Could I make a comment on this?
Please.
There were two lines of argument that
That's
were
the first
raised.
time I've seen him fight to get a word in with you. Go
Well, I mean, you always call him.
Go ahead.
Go ahead. There were two arguments, one of which I thought was quite dreadful, which was the equal protection argument, which was signed on by 5 justices, saying, in effect, that there was a violation in the way these ballots were to be treated. And that's an area in which, generally speaking, there's a wide degree of state discretion, and there was a hypocritical element there. But 3 of the justices used another argument, which in fact was the one that George Will tracked, which says in Article 2, there's a provision which says that when you have these things, they should be decided under such ways as the legislature shall direct.
The state legislature shall direct.
And it is very clear. There's a recent article by my former student Jonathan Mitchell in the University of Chicago Law Review, which makes it again, that the Florida Supreme Court disregarded every single element of the Florida election code. The authority was given to the Secretary of State. This was not a recount. This was something else, that all the procedures were done wrong.
So it's perfectly straightforward. The Supreme Court says the Constitution gives the authority to decide the terms of account to the legislature. Here's what the legislature said, and the Supreme Court of Florida is disregarding it. Case closed.
It was demonstrably wrong. But you see, the difference between the two theories, and this shows why I think Justice O'Connor and Justice Kennedy essentially took the wrong prudential path. If you call this equal protection, nobody's done anything wrong. It's just the way the thing comes out. You use this other argument, you're saying that the Democratic justices on the Florida Supreme Court were essentially deliberately lawless. That actually has much more bite to it. But it was, in fact, technically the correct argument. So the way in which the liberal response has been is to attack the equal protection argument, where they have a lot of strength, and to ignore
which is a weak argument.
Yes, which is.
I don't think it's a totally weak argument.
Not hopeless, hopeless, but not totally.
Well, there has to be some level of review, right?
If four different counties,
Court had flipped a coin,
there were 4 different counties that were engaging in a recount at this point, and the 4 different counties quite clearly had established or were permitting to emerge 4 quite different standards for counting Chad and voters in town.
So that's crazy. I mean, and
it's crazy to permit it, or it's crazy to bring the Constitution to bear.
Well, what it is it's crazy to allow the Florida procedures to be disregarded, so it brings that particular kind of result on. And what they did, in effect, is they took all the power out of the Secretary of State, who was a Republican, who actually played at state, and they put it into the Dade County guys. And what they were doing is they were probably using differential standards with respect to the Chads and so forth. That's why you have centralized administration, so get some degree of coherence.
Elsewhere in his review of the 10th anniversary of Bush versus Gore, Jeffrey Toobin of The New Yorker says, I can't quote it, but I can paraphrase it, I can make the argument for you, says, the Supreme Court tends to cite major cases often. So
they won't
Brown
cite,
versus Board has been cited so and so many times. The number of times this has been cited over the last decade, 0.
Well,
by the court's own standards, they're uncomfortable with this. It's messy. It's
no. It's a one-off case.
I mean, happened again. I mean,
and not only that, if you take the narrow,
you got it right.
Yeah, yes. I mean,
well, the great thing about what the court did here is that it settled something
hopeless.
Finally. Right? There's this famous quote. It's more important that the Supreme Court be final than it be correct, right? And final rather than infallible, actually, is the correct. Yeah. In this case, that's right here. The country could not survive endless fighting over the selection process for the president. And that's why he hasn't been cited, because the court settled the matter and we went on with regular politics, quite a consequential presidency, so make the case.
But
and that was it. We don't need to decide that issue ever again.
The interesting thing is, and there was a flow back, which in the lower courts, Bush v. Gore, on the question of how it is you organize every other kind of state election, the equal protection stuff comes in there, and all it did was to contribute immense amounts of confusion. This is a classic case in which where you take the kind of judicial, prudent, low-level argument, what you do is you get into all sorts of trouble. You want a rifle shot on this one. You want to kill this election off, and you don't want anything else to happen.